Dear students, I hope you are doing great. In the previous semesters, especially the second or even the first semester at the first level at Al-Azhar University Faculty of Law, we illustrated the course named Public International Law Part 1, in which we should shed a light on the essence and the sources of public international law. As I discussed the definition of public international law, the traditional view and modern view of international law, and the traditional definition and the differences between this definition and the modern one regarding the sources, the subjects of international law, even the period that the international law had experienced. Then I moved to the sources of the international law. So I illustrated in details what are the main sources of the international law. I started with the treaties and the difference between the treaties according to the VCLT, the Vienna Convention on the Law of Treaties 1969, and the difference between the treaties and the conventions and their general meaning. Um, Also, I discussed the stages of making a treaty, the ratification on the treaty, the interpretation of the treaty, and all the matters that are related to the first source of international law, that's to say the treaties. Then we moved to the customary international law. We defined the customs and we knew what are the main elements of the custom, whether the uses or the material element or even the opinion is the mental element, and whether it is important to have the two elements or is it sufficient to have only one element for the international custom. I think we discussed all of these matters in a lot of details. However, in this semester, inshallah, we will move to the other topics within the field of the international law as the mother of the branches of international law. So as shown here, we will discuss selected topics, specific topics on the international law, um, as we will discuss four or five main issues, starting with the subjects of international law. I mean, who are the persons of international law? Also, the maritime scope of the state. I mean, the the sea, the territorial waters, internal waters, and the other zones in the sea, the rights and the duties of the coastal states and the non-coastal states. Then we will be talking about the peaceful settlement of the international disputes, also uh, the international responsibility. This material, you will find it in the library or the stationery. I don't know. You can find it anyway في مكتبة اسمها مكتبة الطالب. في كل الأحوال هذه المادة أنا مستقيها من عدة مصادر ومراجع مهمة. وليد عبد الرحمن من جامعة بيروت العربية، فيصل طه كتابه كان ممتاز جدا في هذا الموضوع، اللي بيحب يستزيد ممكن يحصل عليه. بالإضافة إلى راندل ليسفر from Tilburg University, Belgium, Carlos Sherman, Yale University in the US, and Malcolm Shaw, and he is one of the famous people who wrote in the field of international law from Britain. Anyway, so these are the main resources that I depended on in making the material for this course. So the chapter one here is titled Subjects of International Law or Persons of International Law. Who are the persons of international law? Look, to know what person mean in any law, the person is any entity which is capable of rights and duties that are enshrined within a statute or a law. So let we consider that we have a law that is named the law A. Okay, we have a law, and this law is named A. And at the same time, we have an entity. This entity is called X, for example. Look, we can say that this X is considered a person or even a subject of the law A if we discover or find out that the law X direct his speech directly to the entity X. So what is the criteria to consider that an entity is a subject of a law, whether a national law or even an international law? When the law directs its speech to this entity and decides what are the rights and the duties of this entity, we can say that this entity is considered a subject of the law. Okay? And this entity will be considered enjoying what is called the international personality. الشخصية الدولية يعني هو شخص من أشخاص القانون الدولي. عشان هيك بنقول أي entity بخاطبها القانون الدولي العام بأحكامه، بحدد حقوقها وواجباتها، بقول عنه لهذا الانتيتي الكيان اللي بتكلم عنه بقول عنه شخص من أشخاص القانون الدولي العام. In a way, this is not the course Public International Law Part 1 to talk about these matters. I want to say that the first subject of international law, the first entity which is entitled with the rights and the duties of international law is the state. اوكي؟ يعني اول شخص من اشخاص القانون الدولي العام بخاطبوا القانون الدولي العام باحكامه او القانون الدولي العام بوجه خطابه الهم هم الدول. عشان هيك the traditional definition of international law was that the law or the international law is the law or the rules which regulate the relation between whom? Between states. لأنه الستيتس كانت في هذاك الوقت هي الشخص الوحيد من أشخاص القانون الدولي العام. لكن بتعرف أنه الكيان هذا الوحيد كان في زمنه، لكن فيما بعد أصبح هناك كيانات أخرى بخاطبها القانون الدولي العام بأحكامه، وبالتالي أصبحت تعتبر subjects of international law and they enjoy the legal personality or the international personality. Thus, the modern definition of public international law differs from the traditional definition, as we consider that or define the international law as the body of rules which regulates the relations among subjects of international law. Why subjects? Because we have the state, we have the international organization, we have the individual himself, we have the multinational companies, and the other subjects. Now, in this chapter, inshallah, we will be talking about these subjects of international law in more details. So, if we consider that the state is the first subject of international law, we will shed the light on the state. What is the state? What are the pillars of the state? And so on. Okay? Then the international organizations, do they enjoy the international the international the international personality? Yes, they enjoy it. How come? We will know when we get to this point or get to this topic. I mean, the international organizations. Also, the individual. Do you think that the individual is considered a subject of international law? Is international law directing his speech to this individual nowadays? Well, this is what we will know, inshallah, in the coming lectures. So, subjects of international law, we will start with the meaning of being a subject of international or the international personality. كل من بجد بقول personal بقول responsibility فكر حلو international criminal law. Anyway, then after defining what is the legal personality, we will start with the states as the first persons of international law. So the subject of international law ايش يعني انه يكون شخص من اشخاص القانون الدولي العام او بيمتلك الشخصيه القانونيه؟ قال لي is a person or entity who possesses international legal personality. طب ايش يعني؟ انا ايش يعني شخص من اشخاص القانون الدولي؟ يعني هو الشخص اللي عنده شخصيه قانونيه دوليه؟ ما فسرش شيء. That's to say if this entity is capable of possessing international rights and obligations and having the capacity to take certain types of actions on the international level. So to consider any entity a subject of international or as subject of international law, this entity shall be capable of rights and duties under international law. أول إشي. Number two, this entity is able to conduct certain types of actions at the international level. اوكي؟ عشان اعترف لشخص ما بالشخصيه الدوليه واعتبره انه والله هذا من بين اشخاص القانون الدولي العام، لازم يكون قادر على تحمل الالتزامات اللي بيفرضها القانون الدولي، يكتسب حقوق بيعطيها القانون الدولي، والقانون الدولي يعني مختصر الكلام the international law directs speech to this person directly or indirectly. المهم لازم يكون القانون بيوجه خطابه مباشرة لهذا الشخص. Traditionally, states have been the only subjects of public international law. And this is according to the traditional definition of international law as the law which regulates the relations between states. However, with the establishment of the international organizations at the international level, it has become necessary that a sort of international legal personality be granted to these entities. It's important to recognize the international personality to or over such international organizations. لأنه ما ينفعش يكون في عندي في المجتمع الدولي organizations بدون وجود قانون يحكم سلوكياتها. يعني زي زمان لما كان القانون الداخلي موجود بالدرجة الأولى كان بيخاطب مين؟ الاندفيدوالز. بعد هيك وجدت فكرة الشركات. ما هو لو الشركات بدهاش تخضع للقانون والقانون يعتبرها شخص من أشخاصه، معناته وكانت هذه الشركات ممكن أن تعمل بمعزل عن نصوص القانون، وبالتالي ممكن تتاجر بالمخدرات، تقوم شركات بالإتجار بالبشر إلى آخره. لذلك القانون لما أصبح قانون الشركات بوجه خطابه إلها أصبحت الشركات شخص من أشخاص القانون الداخلي. نفس الفكرة لما بظهر في المجتمع الدولي إلى جانب الدول international organizations. These international organizations shall not be left free without being limited or even without being bounded by the international rules which يعني governs the conduct of such international organizations. خصوصا انه هذه international organizations can conduct actions that are considered effective in the international level. Okay, thus the international organizations became here or become, as a matter of fact, subjects or even persons of international law. Besides whom? Besides the states. That's why states and international organizations, it led to the amendment for or altering the definition of the traditional definition of the international law. So the international law is not the law that regulates relations between states only. It regulates relations between public subjects of international law, states, organizations. Besides states and international organizations, non-state entities such as member of federal states. There are entities that are not considered states, but they combined to each other, they can constitute a state, and this is what is called the federal states. Like the US, for example, it consists of different states, small states. When they combine all together, they constitute a state. Now, the state of the US, it has the legal personality because it's a state, and the states are the first person of international law. However, do you think that the federal states inside the US, like for example New York, New Jersey, do you think that these, um, like Washington, these states, do they enjoy the international personality? Are they considered subjects of international law? The answer is yes, and we will discuss this later. So, states, organizations, the entities within the federal state, the belligerents under international humanitarian law, the insurgents in cases of the internal disturbances, uh, and the non-international conflict, the national liberation movements, like what we know here in Palestine, and the international territories are granted sort of international legal personality, and we will talk about them later. Special international status was granted to the Holy See and the Vatican City. حتى في مدينة الفاتيكان يا جماعة، والهولي سي اللي هي احنا بنسميها آه، الدولة اللي بنسميها الكرسي الرسولي، أو بنسميه الكرسي البابوي. يعني هذه شغلة حنشرحها فيما بعد، هي أمر مختلف تماما عن الفاتيكان سيتي. يعني الفاتيكان سيتي هي المكان أو الإقليم واللي موجود فيه كيان تاني اسمه الكرسي الرسولي أو البابوي، واللي له شخصية مستقلة تماما عن الفاتيكان سيتي كفاتيكان، كدولة فاتيكان، حتى لم تصبح سيتي أو مدينة، هي أصبحت دولة فاتيكان اللي هي موجودة داخل إيطاليا كمان، ولكن تتمتع نوع من الشخصية القانونية الدولية، والقانون الدولي بوجه أحكامه إلها وبتعامل معها كشخص من أشخاصه. فبرضه حنتحدث عن موضوع the Holy See and the Vatican City، حنتكلم عن the Sovereign Order of Malta، هنتكلم عن موضوع دولة فرسان مالطا وموضوعها يعني شديد التعقيد، لأنه حتشككوا في حالكم في مبادئ القانون الدولي اللي أنتم درستوها. Also the individuals، الفرد يعتبر برضو من قبيل أشخاص القانون الدولي العام and the other subjects of international law. What I would like to say here is that we have many forms, many images, many subjects even for the international law. We have the state, organizations, entities within federal states, multinational companies, Holy See, Vatican City, the Special Order of Malta, the individuals themselves. They are all considered to have the legal personality or the international personality, and accordingly they are considered subjects of international law. So all of this um, introduction is because I want to tell you that we do not have only one person of international law, the state. We have more than one person of international law. So we will start with the most famous person of international law, the states. So here we will define the state, the elements of the state, and the other topics or the results of the elements of the state. So states are the original and major subjects of international law. This is a true fact. This is a matter of fact. No one can deny that the state are the original and the major subjects of international law. The only school which is considered against this fact is the French school, or the school of George Sell and Charles D. Fisher, because they considered that the individual is the only person of international law, because the individual is the cornerstone in constituting the state, because without the individual there will be no population, فيش شعب, and when there is no population then there is no state. So they considered that the individual is the only person who is considered a subject of international law and national law. لكن في نوع من الاكزاجريشن في الموضوع، لأنه في النهاية الدول هي كيان معنوي أصبح موجود ويفرض نفسه على الساحة الدولية، ولا بد من وجود قانون ينظم سلوكيات هذه الدول كأشخاص منفصلة تماما عن شخصية الأفراد العاديين، حتى ولو كان هم اللي بيشكلوا الشعب. فعشان هيك بنقول إنه هذه النظرة فيها نوع من المغالاة، وإحنا مع الناس اللي بتعتبر إنه the states are the subjects of international law, but we do not يعني consider that these states are the only persons of international law. So back to this line, states are the original and the major subjects of international law. Their legal personality is derived from the very nature and the structure of the international system. All states, by virtue of principle of sovereign equality, uh, enjoy the same degree of international legal personality. يعني الفكرة بدي أقولها إنه كل state موجودة في الانترناشونال level or the international society they enjoy the same legal personality. Every state has international legal personality and they are virtually and theoretically they are equal to each other. الشخصية اللي بتتمتع فيها الدولة الأولى US the same as the international legal personality that is enjoyed by Palestine, okay, and by Lebanon and whatsoever. International law is primarily concerned with the rights, duties, and interests of states. Normally, the rules of conduct that international law prescribes are rules which states are to observe. So every state shall be bound by the rules which constitutes of duties, interests, and rights. Okay, there is nothing new here. Since a state is primary concern of international law, it's necessary to study this state in a separate chapter. Thus, the next pages, inshallah, of this work is devoted to the study of the state as subject of international law, mainly pillar of the state and its problematic shall be illustrated well and in a clear-cut manner. Anyway, the question that we will start with this lecture is what are the main pillars of the state? Look, you have to know that the state has three main pillars according to customary international law: the territory of the state, the population or the people of the state, and the sovereignty, and this is not correct. So I need you all to replace the word sovereignty with another word, which is the authority. So the authority must replace the word sovereignty. Why the sovereignty? The sovereignty is not an element, the sovereignty is a result of an element. يعني الأركان الثلاثة هي الشعب والإقليم والسلطة السياسية the political authority، بترتب على قد يترتب كمان على وجود السلطة وجود السيادة. لأنه بعض الدول لو بدنا نقول إنه السيادة the sovereignty is a pillar of the state, then a lot of entities will lose their international statehood or the character, the statehood characteristic. Like what? Like Palestine, for example. It lacks the sovereignty. So if we consider that the sovereignty is an element, then Palestine is not a state. So we have to replace the sovereignty with the authority. And the sovereignty is one of the effects or even the results of having the national or even the political authority. Now, I need to tell you something because you may face during your study or during or when you read some books in the field of public international law which discusses the state as one of the subjects of international law, you will find some sources which says that or considers that the state is based on four main pillars: the territory, the population, the government or the authority, and the capacity to enter into relations with the other states. And this is actually is considered by the Article 1 1933 Montevideo Agreement. اتفاقية مونتفيديو المبرمة ما بين دول أمريكا اللاتينية بالأساس أعطتني ركن رابع لوجود الدولة، وهي قدرة الدولة على الدخول في علاقات مع الغير. في كل الأحوال we cannot say that it reaches the threshold of customary international law. ليه؟ لأنه هذه الاتفاقية قاصرة بحسب مبدأ Recenteralis Acta only to the states who are parties to the Montevideo Agreement. So it applies only to the state parties. However, the other states are applying in their relations, or they apply in their relation the customary international law rules, and which says that there are three main elements of the state: the territory, the population, and the government, or even the national or the political authority. So let's start with the population as the first source or the first element and first pillar of the state. So what is the population? The state is a community of persons. It is a human political institution. Without a population, there cannot be, or there can be no state. So let's agree here that the population is an important element or pillar. أصلا حتى في اللغة العربية الركن لقيام الشيء هو ما لا يقوم الشيء إلا به أو بوجوده. فإذا فقد ركن الشعب لا يوجد أن أو لا يمكن أن تقوم للدولة قائما. Population can be more or less. Uh, I don't think that this is phrased so well. أصلا هي المادة مش منقحة حتى الآن. كل الأحوال إنه there is no specific number for the population. This is what you have to know. So the population is maybe in certain states it doesn't exceed like 10,000 persons, or the population as whole is 10,000 persons. However, in another state, you can find a state where the population of uh, 1 billion population. So the number of the population is not important, is not a condition to say that there is a population as pillar of the state. So there are states with very small population like Switzerland, Canada, and the others. And there are states like China, India, and others with very large population. So what matters here is that the number shall not reflect a case of triviality. مش لازم يكون العدد واصل إلى حد التفاهة. يعني ما ينفعش يكون في عندي 400 نفر وتيجي تقول لي عندي ستيت. صح ما فيش قاعدة محددة بخصوص العدد، بس العدد هنا يشير إلى التفاهة. وأنا من هنا بأحيلكم إلى فيلم تحضروه موجود على نتفليكس and it is said that it is based on true story. اسم الفيلم The Rose Island. تحكي عن شخص كان ناوي هو وصديقه يعملوا دولة، وبالفعل ذهبوا إلى منطقة في أعالي البحار خارج المياه الإقليمية الإيطالية، وقاموا بزرع دعامات حديدية داخل البحر، وأقاموا إقليم لا تتجاوز مساحته المترات، وكان بينقصهم وجود population، وبدأوا بعمل population، لكن في النهاية طبعا تم إنهاء مشروعهم. فبإمكانكم تطلعوا على فكرة الفيلم، خصوصا إنه في بعض الجوانب القانونية في الموضوع، بإمكانكم تشوفوه لأنه الفكرة تبعته مهمة كتير. في كل الأحوال بعيدا عن الدعايات اللي أنا بعملها لنتفليكس، بنقول إنه the number of the population is not important here unless it reflects cases of triviality. The people living in the state are the citizens of the state. And they enjoy rights and freedoms as citizens, as well as perform several duties towards the state. So when citizens of another state are living in the territory of the state, they are called aliens. I don't think that this adds something new to your knowledge. All the persons, citizens, as well as aliens who are living in the territory of the state are uh, duly bound, not duty, duty bound, duly bound to obey the state laws and policies. The state exercises supreme authority over them through its government. This is a repetitive idea and repeated one. It says that there is no definitive limit for size of population essential for the state. However, it is recognized that the population should not be uh, or should be neither too large nor very small. It has to be within a reasonable limit. It should be determined on the basis of the size of the territory of the state. So when the state is a big one, it's made that the policy of that state encourages the people to increase their number, or even it allows people to come to the state in order to be naturalized عشان يتجنسوا. Naturalization يعني التجنس. And in order that the state will grant them the nationality after a specific period of their accommodation within the state. Okay, the available resources of the state also it yeah, خلينا نقول it controls the policy of the number of the population, the standard of living expected, and the needs of the defense, the production of goods and supplies. So India has a very large and fast growing population, and there is every need to check population growth. It is essential for enhancing the ability of India to register a high level of substantial development. The question here is this number of population considerable. This is to sum up the all what has mentioned above. So there is no specific number that the population of the state shall exceed, but it shall not be so trivial at the same time. Okay, so this is the question that we end our lecture with. The coming lecture, inshallah, we will shed the light on the second pillar of the state, which is the territory of the state, and it is the most important part and the most debatable one. So prepare yourself very well for the coming lecture. Thank you very much. Thank you for your patience, and goodbye.